All right, we'll go back on the record. It's 9 a.m. on August 17th, 2023. This is the continued hearing of case number 28907. And Mr. Vivian, do you have a witness to call?
Yeah, we call Neil Ernest to the stand.
Neil Ernest? And could you spell your name, sir?
Neil-Earnest.
All right, thank you. Could you raise your right hand, please? Do you solemnly swear or affirm under the penalties of perjury that the testimony you're about to give in this matter will be true and correct to the best of your knowledge and belief?
I do.
All right, Mr. Vivian?
Good morning, Mr. Ernest. Before we talk about your background, would it be helpful if we had your expert report in front of the commission?
Yes, it would be.
Okay. If you could turn to Exhibit 17 in the black binder. Is Exhibit 17 the report you prepared in this matter?
It is.
I would offer Exhibit E17.
No objection.
And
Exhibit is received and admitted.
thank you. Starting on page 4, it talks about an introduction. If you could tell the commission a little bit about your background, that'd be great.
I've been in the industry for now a bit over 40 years. I hold a BS in chemical engineering from Michigan State, an MBA from the University of Houston at Clear Lake. I am also a professional engineer licensed in the state of Texas in the discipline of chemical engineering. I started at a refinery, Phillips Petroleum, owned by Phillips Petroleum at that time, now a bit over 40 years ago. I worked for Phillips for about 11 years in a variety of refinery and corporate headquarters positions before I joined Muse Stansel in late 1991. Since I've been with Muse Stansel, I have been engaged by a wide range of clients around the world on a wide range of subject matters. But the core of my expertise is in what I refer to as a downstream of the wellhead, including midstream and the processing of the oil and gas products that are transported by the midstream sector to the refineries and gas processing plants, as well as the transport of the refined products to the end users.
Could you talk a little bit about the types of experience that you think are particularly relevant for this matter?
Sure. And there's further details here on page 4 and page 5 that I'll let you review at your leisure. But some of the midstream engagements that I'm involved in, I very much consider this matter that we're talking about here today to be a midstream issue. Concerns market and competitive analyses regarding various midstream issues or assets, analyses of various midstream logistical options that they may or may not have, competitive positioning analyses for midstream companies, technical due diligence on such midstream assets as pipeline storage facilities, and finally the assessment of the implications on pipeline throughput and changes on the rates or tolls charged by the pipeline company. I've also testified in a number of venues regarding midstream issues. Those venues include the U.S. Federal Energy Regulatory Commission, the Canada Energy Regulator and its predecessor entity, the National Energy Board of Canada, the representative examples of my FERC experience include assisting Colonial Pipeline with various rate matters and an engagement regarding Enbridge pipelines concerning the appropriate rates concerning a pipeline that transported diluent from the United States back up into Canada called Southern Lights. I've also testified on numerous non-rate matters before the FERC, the Canada Energy Regulator, the National Energy Board, the ICC International Court of Arbitration, and several state regulatory bodies such as what we have here. I have also provided expert testimony in support of 2 Bakken crude oil pipelines, which in part informs my, it constitutes my background regarding the Bakken area. And those projects were specifically the Sandpiper project sponsored by Enbridge that would have connected North Dakota to the Superior, Wisconsin, that never proceeded, and a second Enbridge pipeline project that did proceed that connected North Dakota to Cromer, Manitoba, where it intersects with the Enbridge main line.
Have you ever been employed or had an ownership interest in any of the parties in this case?
No,
And were you receive any assistance in preparing your report?
I do. I'm not an individual consultant. I'm the chairman of Muse Stansel & Co. And Muse Stansel & Co. is a boutique downstream consultancy. And I was assisted both by my staff and other colleagues in the preparation of analyses of the facts and issues at hand here, as well as in the preparation of my expert report.
Have any of those folks been direct or contract employees of any of the parties?
No,
And you were retained by Frederickson and Byron in this matter?
I was.
And what were you asked to do?
What I was asked to do is spelled out on page 6, paragraph 1.11 in my expert report. But specifically, I was asked to opine on the appropriate methodology to be used to assess the proper costs and expenses associated with saltwater transportation via pipeline for the period 2013 to April 2021 in the local market in which Equinor Energy operates. I was also asked to assess the reasonableness and appropriateness of the saltwater pipeline transportation costs estimated by Equinor Energy, and provide a critique of the expert report submitted by Mr. Hansen, who, as I understand it, represents Versa Energy in this matter.
And now, before we get into your opinions, I'd like to transition to a slide deck that you prepared in connection with your testimony today. Everyone has that, right? And I want to talk about some of the background in connection with your project, and specifically slide 2 of your slideshow. What is the purpose of this slide?
Mr. Ernest, can I get you to turn a little bit my way? I know it's awkward, but I can't see you, and I'm looking at your back.
Yes, it is indeed awkward.
Yes.
You're not my target audience, unfortunately.
I know.
Would it be easier if he and I switched positions?
That would probably work.
Okay,
Sorry.
not a problem.
No, I
Get a
understand
good record,
completely.
though. Thank you.
Thanks. Thanks. Okay, slide 2, Mr. Ernest. What are you intending to convey here?
Slide 2 is simply intended to memorialize, or articulate exactly what the parties were, or that are involved in this matter. I think it's now well understood at this point, but this is really more for completeness as much as anything else. As you'll see, I use these terms Equinor Energy, Equinor Pipeline later in this presentation, and indeed in my expert report, and the precise definition of those terms, if you like, is found here on slide 2.
One question I wanted to ask, the ownership of Versa in these wells was approximately 1.49%.
That is my understanding.
Is it your understanding that some of these wells were governed by a JOA?
That is my understanding as well.
If you could turn to Exhibit 1 in the black book there. Have we distributed the signature pages, Spencer? It is Exhibit E1, the JOA, that you understand covers some of these wells.
Yes, it is.
And there's been a signature page distributed with a signature on behalf of Brigham Oil and Gas. Are you familiar with that?
I have seen it, yes.
And where did that come from? Where did you see it?
It's part of the documents provided that we considered over the course of the engagement.
Okay. I'd offer Exhibit 1.
No objection.
Exhibit E1 with the attached document
Yes, that's our intention.
is received and admitted.
You could turn to Slide 3, Mr. Ernest. And again, I think this is well understood, but what is your understanding regarding the sale of Versa's and Equinor's respective assets?
My understanding is that Versa Energy sold its assets on or about February 2022. It's further my understanding, or quite clear understanding, that Equinor sold its upstream and midstream Bakken assets on or about April 27th, 2021. I would note I heard some different dates offered by Mr. Hansen yesterday regarding the timing of the sale of the Equinor assets. I believe the April 27, 21 date to be the correct date.
If you could turn to Slide 4, please. And this is titled Summary of Your Opinions. And what are your opinions?
I have four key opinions I'd like to offer here today. The first simply is that the principle of using arm's length pricing for the provision of goods and services between subsidiaries, or indeed operating divisions, is long and well established. Subsidiaries regularly transact business with each other and with third parties. And subsidiaries, in my experience, provide goods and services to other subsidiaries at arm's length prices. Said differently, they provide goods and services to sister companies at approximately the same price they would provide those same goods and services to a third party.
Did that happen here?
Yes. As I'll explain further in this opening presentation. My second key conclusion is that Equinor Pipeline provided saltwater pipeline transportation services to Equinor Energy at reasonable and appropriate rates. It is my finding that Equinor priced these transportation services based on appropriate market alternatives, or said differently, they used an arm's length pricing methodology for determining, based on truck transportation, to determine the appropriate transfer pricing between the subsidiaries. As we heard yesterday, they solicited bids from various trucking companies, aggregated those bids, to establish the appropriate arm's length price for the provision of transportation services from Equinor Pipeline to Equinor Energy. And I'd further add that Equinor periodically reviewed the appropriateness of these transfer rates and adjust them as necessary based on current market conditions, all of which I find to be reasonable and appropriate. My third conclusion is that the arm's length pricing for saltwater pipeline transportation also equals the approximate opportunity cost incurred by Equinor Pipeline for the provision of those services. And I'll elaborate on this concept later in this opening presentation. And finally, I find that the Versa Energy Expert Report, or more generally, I refer to it as the Hansen Report, is flawed. The opinions and the damages estimates are unfounded and unreliable.
If you could turn to slide 5, please, which is titled Equinor Subsidiary Structure. Did Equinor separate related business activities into subsidiaries?
Yes, it did. And this division of Equinor Energy, i.e. upstream, and Equinor Pipeline, which has held its Equinor's midstream assets, is very consistent with typical oil industry practice. It's unusual to do anything but to separate these rather different business activities into not to separate them into other subsidiaries or at least operating divisions.
Why do corporations do that?
They have a number of reasons. Some has to do with internal governance. If you have discrete business activities such as upstream and midstream separated in your reporting structure, it's easier to track expenses and costs. And if you can track expenses and costs, you can manage those same expenses and costs. It enables upper management to meaningfully monitor and assess lower management performance, reward those who are doing well, and do something different with those who are not doing so well. And there can also be other corporate reasons or business reasons for establishing discrete businesses in a separate legal subsidiary. For example, at some point in the future, a corporation may elect to sell their midstream assets to another, and having those midstream assets in a separate legal structure, i.e. subsidiary, is helpful to that end.
Does the subsidiary concept make sense if prices are not market-driven for the services?
In my opinion, no, it does not. I heard some testimony from Mr. Hansen yesterday that he was surprised or disturbed that there was no evidence that Equinor Energy negotiated the pipeline transportation rates with Equinor Pipeline. And that negotiation presumably would have driven down the pipeline rates. I would point out that concept is symmetrical. That also means that Equinor Pipeline would be free to negotiate with Equinor Energy to increase the pipeline transportation rates. Where you end up in that kind of negotiation, in my opinion, is a function of the internal power dynamics among Equinor management. Would have nothing to do, your endpoint would have nothing to do with the actual arm's length pricing for that kind of transportation service. If you're seeking to establish a reasonable, appropriate rate for pipeline transportation services, you don't do it by internal negotiations. You do it by looking to the market for the provision of very similar transportation services. And indeed, that's what, in my opinion, Equinor has done here in this matter.
If you could turn to slide 6, please. What were the transactions between the Equinor subsidiaries in this case?
I believe they're well understood, and I'll move through this quickly. As I think it's now well understood that produced water at the Equinor operated wells was primarily transported by pipeline to disposal wells, both disposal wells owned by Equinor Pipeline and various third parties. Whereas flowback water tended to be, as I understand it, was generally trucked from the production wells to a disposal well. Equinor Energy relied upon Equinor Pipeline for the provision of these transportation services by pipeline, as well as the provision of saltwater disposal in injection wells. And it's further my understanding that there is no dispute between the parties regarding the saltwater trucking costs, whether that trucking activity was initiated by Equinor Energy or Equinor Pipeline, nor is there any dispute regarding the saltwater disposal well charges. I would point out at this point that the methodology used to establish the fair rate or the appropriate rate for saltwater disposal is the fair tender process.
And before we talk, oh, I'm sorry to interrupt. Before we talk about the fair tender process, I just wanted to touch base on one distinction to make sure everyone's on the same page. What's the difference between flowback and produced water, and why are they transported differently?
My understanding is the flowback water can contain sufficient levels of contaminant such that not all disposal sites are prepared to take that water, and that Equinor Pipeline would prefer, rather strongly prefer, not to have that type of water with potential high contaminant load in their pipeline system. Thus, it's just trucked for approximately 30 days after a new well comes online.
And before we talk about the fair tender process, I just wanted to touch base on some exhibits that you relied on. If you could look at Exhibit E6 in the black binder.
Can I have it?
Is this something that you reviewed and relied on?
It is.
Okay. I would offer Exhibit E6.
Is that already in the record?
Well, it came in through Ms. Beck, so I was just,
Oh, sure. I'll stipulate to that.
Okay.
No objection to Exhibit 6.
same for E7 and E15?
Correct.
Okay.
I have no objections to those.
Receive and, are you going to separately introduce those, or do you want to?
No, I just don't want them to not come in if Ms.
Sure.
Beck's testimony is later stricken. So,
I'll receive and admit E6.
and E7 and E15?
Okay.
Okay, thank you. If you could turn to slide 7, please, Mr. Ernest. What was the fair tender process and what was its objective?
The objective of the fair tender process was to establish an appropriate arm's length cost or rate for saltwater transportation services between Equinor Energy and Equinor Pipeline. And the methodology used for the fair tender process, be it either for the transportation by pipeline to saltwater or the disposal of saltwater in injection wells, was to solicit multiple bids from companies that could provide those services. We heard yesterday that the first fair tender process took place formally in 2013 on the part of Equinor. That process was repeated in 2015, and that's the numbers I'm specifically showing you here now with slide 7. And the process was fairly straightforward. Solicit quotations from service providers, average those quotations, and that constituted the rate used for the provision of transportation services by pipeline that was charged by Equinor Pipeline to Equinor Energy.
You could look at Exhibit 8, or Slide 8, rather. What does Slide 8 show?
Slide 8 is a graphical presentation of tables found in my expert report. The data, the underlying data is exactly the same. What we have on the left is the average of the trucking bids received in the fair tender process in 2015 for the indicated counties, specifically McKinsey, Montreal, and Williams. And I would point out at this point that what we are seeing here, or looking at here, is Muse Stansel's reconstruction of the 2015 fair tender process. At the time of my expert report, we had not located the actual Excel file that Equinor had used to generate the actual numbers that they subsequently used for between Equinor Pipeline and Equinor Energy. That file has now been located.
If you could look at Exhibit E18, please, Mr. Ernest.
I have it.
Is that the file you're just referring to?
Yes, it is. This is the actual file used, or this is a sheet and a workbook, a larger workbook that generated the saltwater pipeline transportation rates that were charged by Equinor Pipeline to Equinor Energy.
And how does both Exhibit E18 and the testimony from Ms. Beck yesterday comport with your opinions?
It's consistent. The numbers differ slightly, but slightly. It doesn't change my overall opinion that the methodology used by Equinor to establish its transfer cost or rates between the two subsidiaries is reasonable and appropriate.
I'd offer Exhibit E18.
No objection.
Exhibit is received and admitted.
Now, before we move on, this came up at the very end of Ms. Beck's testimony. There was a mention of frost loss surcharge. What is that and why does it matter?
My understanding of the frost law surcharge is that there are certain times of the year here in North Dakota where weather conditions prompt the Department of Transportation to impose weight restrictions on certain roads to minimize or reduce the damage caused to those roads. Trucks are, the amount of water, or for that matter oil you can load on the trucks is generally weight restricted. If you reduce the permissible weight that the truck, the weight of the truck, you have to reduce the amount of water you can transport. Since the cost of the truck activity is more or less fixed, the fuel cost, the driver cost doesn't change, even though the amount of water they can transport goes down. The truck companies ask for and get what they refer to as a frost law surcharge during those periods of time when there's weight restrictions. And you see the note here at the bottom of the chart found on slide 8. Those frost law surcharges are in the order of 50 cents a barrel, which is in the context of the overall transportation rates that we see here in the graph of $1.75 or so is material.
Turn to slide 9, please. Did Equinor use the fair tender process after 2015?
Yes, they did. They continue to use it, and upon observing a change in the market conditions for trucking, they went through a third fair tender process in 2019. I'd also point out that in 2019, Equinor Pipeline also entered into a contract with a third-party saltwater pipeline.
And why was that important?
I think it's relevant because this is our only example of an arm's length third-party cost for the transportation of salt water by pipeline. And what we find is that the transportation rate charged by a third party for saltwater transportation is very similar to the transportation rate charged by Equinor Pipeline to Equinor Energy for the provision of exactly the same service. I'd also point out that this contract imposes additional deficiency fees on Equinor Pipeline if Equinor Pipeline doesn't meet a minimum volume commitment. And this minimum volume commitment effectively transfers the revenue risk from Oasis Pipeline to Equinor Pipeline, in which I would submit is a valuable economic consideration for the perspective of Oasis Pipeline. Minimum volume commitments are in contracts for a reason. They have real economic value. I'd also point out that Diversa Energy does not bear the burden of complying with the minimum volume commitment. Only Equinor Pipeline does. And the final point I'd make about the minimum volume commitment is, absent that provision, I would expect the negotiated pipeline rate not to be $1.70 per barrel, but something higher.
And you're referring to the Oasis contract we talked about yesterday?
I am.
Okay. If you could turn to slide 10. What is being summarized and compared here on slide 10?
The presentation is similar to what we saw for 2015. Same three counties. Starting on the left, this is a simple average of the trucking bids received for these three counties from the set of truck companies that actually provided quotations to Equinor at this time. One of the trucking companies, JMAC, for reasons not known to me, submitted bids that were significantly higher or materially higher than the other truck companies. So the second set of columns just provides what those rates would be absent or excluding the JMAC quotation from the mathematical average. The third set is simply the cost that we're just talking about on the third-party pipeline, the Oasis pipeline at $1.70. And the final set of columns is where Equinor landed on the appropriate market-based rate to be charged for the provision of pipeline transportation services between Equinor Pipeline and Equinor Energy. And as you can see, where they landed is consistent with the market data, both the market data as represented by truck transportation costs and the market data as represented by third-party saltwater pipeline transportation costs. And once again, I would remind everyone, as indicated in the note at the bottom of the graph, the pipeline rates determined or settled on by Equinor do not include explicitly any provision for the frost loss surcharges, but nonetheless, that is a very real cost in the marketplace.
If you could look at Exhibit E19 in the binder in front of you, Mr. Ernest. What is E19?
E19 is the part of the development of the 2019 transportation rates between Equinor Pipeline and Equinor Energy.
And did you review and rely on this in forming your opinions?
I did.
We'd offer Exhibit E19.
No objection.
Exhibit is received and admitted.
And the average on the excluding JMAC is $1.74, is that right? On Exhibit E19,
Yes,
which is just a few cents higher than the third-party pipeline rate.
it's 4 cents higher, yes.
We can move on to slide 11. You referred to in your summary an opportunity cost. What is an opportunity cost and how does it apply here?
the opportunity cost concept is not new or novel. It is one of the core concepts of classical economic and indeed financial theory. It has been around for a long time. An opportunity cost is the potential benefit that an individual, an investor, or a business foregoes when it chooses one alternative over another in a circumstance where those alternatives are mutually exclusive. And it's relevant in this circumstance, I believe, for this reason. For Equinor Pipeline, they have a very real opportunity cost for providing saltwater transportation services to Equinor Energy. Because if they're providing saltwater transportation services to Equinor Energy, they can't be providing exactly the same service to a third party and earning third party market-based rates.
We talked a lot about saltwater trucking costs. Why are they important in your analysis?
It's the saltwater trucking costs, or more generally, trucking is the competitive alternative to transporting salt water in the Bakken by pipeline. Because the operators have choices. They can choose to engage with the pipeline company, be it a subsidiary or a third party, to provide saltwater transportation services by pipeline, or they can engage with a number of trucking companies to provide that same transportation service from the same point of origin to the same, or approximately the same disposal sites. And in a very meaningful sense, what the whole fair tender process is doing is estimating the opportunity cost for Equinor Pipeline to provide transportation services to Equinor Energy rather than some unaffiliated third party.
If you could turn to slide 12, please. Did you also critique Mr. Hansen's report?
Yes, I did.
And the report that Mr. Hansen referred to yesterday was slightly revised from the one that you reviewed?
Yes, it was.
Okay. And I believe the original report's been distributed? Oh, okay. And for completeness sake, we have not marked it, but we would ask that the original report be marked as Exhibit E21, and we would offer it at this time.
I have no objection.
Exhibit E21 is received and admitted.
How did you break down the Hansen report for terms of your, for purposes of your analysis, Mr. Ernest?
As discussed in my expert report, when I reviewed Mr. Hansen's report, it appeared to have, not appeared, it did have, in my view, 4 major sections. The first section was a description of the assets owned by Equinor Energy and the assets owned by Equinor Pipeline. I've got no particular quarrel with that characterization by Mr. Hansen. The second major section is an estimate of the operating costs, or really a portion of the Williams County saltwater gathering system owned and operated by Equinor Pipeline. And this section really is the core of Versa Energy's damages case for the 8.5 years that Versa Energy owned its assets in North Dakota. The third section is an estimate of the damages attributable to the purported overcharges on the sale price received by Versa Energy for the sale of its North Dakota assets on or about February 1st, 2022. And the final and fourth section of the report is an analysis using the asset value of Equinor Pipeline to support the purported saltwater transportation overcharges, i.e. what he calculates in Section 2.
Before we move on to the next slide, it's your understanding that Mr. Hansen claims that Versa received a diminished price when it sold its assets?
That is my understanding.
And he says that's because of the alleged overcharges?
That is also my understanding.
Using that analysis, would there have been an impact on the price that Versa paid when it bought its assets?
It would be symmetrical. If Versa Energy was damaged by hypothetically excess saltwater transportation charges when it sold those assets, Versa Energy would have been advantaged or would have paid less for those same assets when it bought them because it would have observed the same level, general level of saltwater transportation costs. It would have been symmetrical.
If you could turn to slide 13, please. In this portion of your critique as deals with the overcharge estimate, what is the fundamental premise in your view of that analysis?
Fundamentally, it's my assessment that Section 2 of Mr. Hansen's expert report is based upon the premise that only transactions between Equinor subsidiaries can result in a potential overcharge. And this overcharge equals the Equinor pipeline saltwater transportation costs for pipeline services only, less Mr. Hansen's estimate of a saltwater pipeline direct operating cost, and less Mr. Hansen's estimate of the simple return of capital over about an 8.5-year period.
What would Mr. Hansen require of affiliates providing services to another affiliate or sister company in this case?
Mr. Hansen is essentially or mathematically requiring subsidiaries to provide goods and services to other subsidiaries on a return on capital basis. Now, I heard some testimony by Mr. Hansen yesterday that indicated that he may, to some degree, not clear to me, modified his view as to whether or not there might be a role for a return on capital in his damages claim. From a damages expert perspective, as I sit here right now, I don't know what the quantum is of Versa Energy's damages claim, given that new testimony by Mr. Hansen. I don't know what they're asking for anymore in terms of dollars and cents.
Mr. Hansen's analysis would require zero return on capital for subsidiaries. What would it do for third parties?
The principle, as I understand it, is that if the third party is providing the good or service, be it trucking service, presumably pipeline services, saltwater disposal services, the actual fee or rate charge is the appropriate measure to use for the determination of expenses. Now, and clearly, other third parties of services, be it trucking companies, be it pipelines, be it disposal wells, they have some profit component built into the rate that they charge. Said differently, they are capturing both a return on and presumably return of and on capital employed by those businesses to provide those services. And I think the tension between the position that it's appropriate for third parties to enjoy return of and on capital, and it's inappropriate for subsidiaries to enjoy the same measure is insurmountable. It's an impossible position, in my view, to maintain from perspective of an expert.
If you could turn to slide 14, please.
If I could
Oh, one more point?
offer
Yes.
one more point. And I would say at this point, this is the final bullet here on this slide 13, you have a threshold decision in front of you here now. Mr. Hansen's overcharge estimate requires the adoption of the principle that subsidiaries must provide goods and services to each other at something other than an arm's length basis, i.e. no return on capital basis. Absent such an adoption, the claim could be simply dismissed. We no longer need to consider, or would not need to consider, the actual mathematical calculations that Mr. Hansen steps through.
If you could turn to slide 14. But we do, for the sake of completeness, consider some of those mathematical considerations. What was the first thing that sort of stuck out to you about Mr. Hansen's analysis with regard to the gathering system?
Mr. Hansen performs his analysis on a subset of the Equinor pipeline saltwater system. He uses what he styles as the Dave Nelson SWD gathering system. This is not a discrete set of assets owned or operated by Equinor Pipeline. It's part of a larger operation. And my observation would be this is a rather concentrated set of wells, and thus the amount of pipeline infrastructure required to service this rather concentrated set of wells is less than is representative, in my general view, of the assets owned and operated by Equinor Pipeline.
Why does that matter?
Well, influences particularly his capital amortization calculation that we'll talk here about a little bit later.
Do you find Mr. Hansen's operating and capital cost conclusions and assumptions to be reliable?
I do not. I find them to lack foundation and indeed to be unreliable.
Why is that?
The estimate of pipeline variable operating cost, 5 cents per barrel, was provided by Mr. Gerbig, who is not here today. Mr. Hansen simply takes Mr. Gerbig's estimate and doubles it. Further, Mr. Hansen provides us with what he styles as an amortized capital expense cost incurred by Equinor Pipeline. And this amortized capital expense is calculated or determined by dividing the estimated capital cost for this self-styled Dave Nelson gathering system provided by Mr. Gerbig by the volume of water transported within that same Dave Nelson system. And the period of time used to determine the volume of water that's divided into this capital cost is 8.5 years. And I'd point out that that includes about 10 months. This 8.5 years includes about 10 months when Equinor Pipeline didn't even own the pipelines that we're talking about here. And this calculation results in the simple return of capital over about an 8.5 year period with no return on capital, or said differently, no profit component.
What are your opinions about Mr. Hansen's concept of amortized capital expenses?
It is my opinion that this concept lacks a fundamental analytical foundation. Consider the hypothetical where Versa Energy owns its production assets for 1 year. The capital cost doesn't change. It is what it is. but the volume of salt water transported changes. It drops by 8 times. You only hold it not 8.5 years, but 1 year. So now the resultant amortized capital expense is now about $2 a barrel. And one would conclude that Equinor pipeline is now undercharging for its saltwater transportation services rather than overcharging it. So the point really is that this concept of amortized capital expense has to work in all circumstances to be a useful analytical methodology. It works purportedly in a special circumstance of Versa Energy, but you try to take this methodology and apply it to other situations, it falls apart. And that's the basis of my conclusion that this methodology lacks a fundamental analytical foundation.
You could turn to slide 15. Let me make sure I'm in the right one. Yes, slide 15. We talked about this a little bit before. Mr. Hansen opined on an alleged impact on Versa's sales price. What do you think about that?
Over the course of my career, I've done a lot of damages work, provided a lot of expert testimony on the subject of damages. I find this to be a highly unusual claim. I mean, the basis of the purported lower sales value is because of claimed saltwater transportation overcharges that the buyer of Versa's assets presumably would have incorporated into its valuation analyses. I would point out that we have no evidence whatsoever as to how the buyer of Versa Energy's assets actually went about their valuation analyses. And I would say again that once again we have some threshold issues to consider when we think about this damages claim. The first threshold issue is if it is true that subsidiaries should provide goods and services at rates based on reasonable arm's length transactions, then we can dismiss this claim because there will be no overcharges and no impact on valuation. Second, if it is true that Equinor cannot be responsible for any reduction in the Versa Energy sales price when it was not the party purportedly overcharging for saltwater transportation at the time of sale, once again, we can dismiss this damages claim without even considering the accuracy of its mathematical calculations. Again, I would point out that Equinor sold all of its Balkan assets, upstream and midstream, almost a year before the Versa Energy sale. Mr. Hansen provides no evidence whatsoever as to what Versa Energy was being charged by the buyer of the
Equinor?
not Equinor assets, but the Versa Energy assets. We don't know what the saltwater transportation charges were in effect, or Equinor doesn't know, and I don't know because I wasn't there. What saltwater transportation charges were being charged in 2022. Equinor was done and gone.
What do you think about the discount rate that Mr. Hansen used?
Mr. Hansen uses a 10% pre-tax claim to discount the future value of his estimate of future cash flow. It is my opinion that no credible financial analyst would use such a low discount rate. If you'd like further detail or observations on this point, I would refer you to my expert report at pages 22 to 24.
What's your overall view on Mr. Hansen's claim of a diminished sales price?
It is my opinion that this particular damages claim for a lower sales price is highly speculative. It's excessive, lacks foundation, and it can be dismissed.
If you could turn to slide 16, please. Mr. Hansen also offered some opinions about the value of the Equinor pipeline assets. How did you view that analysis in the context of his larger opinions?
This is section 4 of Mr. Hansen's report. It appears to be offered in support of Mr. Hansen's overcharge calculation, i.e. section 2, rather than a specific estimate of damages. As is the case for section 2 itself, this section can be ignored if we adopt the principle that subsidiaries should provide goods and services at cost based on reasonable arm's length transactions. Furthermore, this particular analysis here in section 4 suffers from an unreasonable assumption that saltwater transportation services should be provided on a zero return on capital basis, and he further includes the free cash flow generated by the saltwater disposal assets also owned and operated by Equinor Pipeline in his valuation calculation, which acts to inflate the purported overcharges.
Before moving on to the next slide, Mr. Hansen, in his testimony yesterday, suggested that you and he agreed on something in section 5.8 of your report, which again is exhibit E17. If you could go there. This is on page 20 of exhibit 17, paragraph 5.8. And I believe Mr. Hansen bolded the sentence that you wrote that wrote, "Of course, such a sale would leave the working interest owners like Versa Energy in the same place." Oh, sorry, I'm wrong. The sentence above it. "In effect, Equinor Pipeline would capture the market-based rates in the sale price." What do you mean by that, and do you and Mr. Hansen have common ground there?
The use that Mr. Hansen attempted to put this section of my expert report, I think, has been somewhat misplaced. The observation that I am making here is really somewhat separate from the overall damages claim. It's an observation based on my industry experience, what the implications would be if the commission adopted the principle that subsidiaries should provide goods and services to each other on a return of capital basis only. It's my observation that a very predictable reaction on the part of industry would be parties that held both upstream and midstream assets would sell one or the other. And if Equinor, for example, is selling Equinor Pipeline to some third party who's interested in owning and operating midstream assets, per Mr. Hansen's concept, that third party could charge market-based rates because it's a third party, and in effect, Equinor would capture those market-based rates by its sale price. That doesn't mean, and that means simply that. It doesn't have anything really to do with the appropriateness of the calculations and overall methodology of Mr. Hansen.
If you could turn to slide 17, please. Just want to discuss some of your final thoughts on the corporate structure and permissible charge issues. Would the position advanced by Versa and Mr. Hansen in this case have impacts only on saltwater transportation?
I don't think so. I mean, obviously, this case specifically concerns just saltwater transportation services, but the precedent, the commission may establish would appear to apply to the provision of all goods and services provided between subsidiaries. If it's appropriate for saltwater transportation services, I can't think of a reason why it wouldn't also be applied or be applicable to crude oil and natural gas transportation services provided by, well, in this case, Equinor Pipeline to Equinor Energy.
Let me ask you a question about that. Do you think a oil company that chooses to have both upstream and midstream affiliates that contract with each other should be punished for that?
I can't think of, an economic or policy reason why that concept would have merit. Now, I'd further observe that if we adopt this principle that subsidiaries can only provide goods and services on a zero return of capital basis, or just on a return of capital basis, there's no return on capital, the implications or impacts could be wide-ranging. You would see, in my view, the predictable action taken would be the sale or separation of subsidiaries.
Are there alternatives to an outright sale in this scenario?
Well, there may be, and this is where the implementation of such a policy runs into, pretty quickly, I would say, runs into such issues as, well, what if Equinor Pipeline sold a 1% equity interest to a non-affiliate, to a third party? Does that instantaneously transform Equinor Pipeline into an arm's length third-party provider for the provision of goods and services to Equinor Energy? Which, and again, per Mr. Hansen, an arm's length third-party provider provides goods and services at market-based rates. I would note that if Equinor Pipeline, or indeed any midstream company, had a 1% or 5%, proportion doesn't matter, non-affiliate owner, that subsidiary, management of that subsidiary has a fiduciary responsibility to their non-owners. Said differently, if Equinor Pipeline had unaffiliated owners, it is my opinion that providing services to Equinor Energy at something less than fair or market-based rates would appear to be a breach of their fiduciary responsibility to their non-affiliate owner. In effect, Equinor Pipeline would be transferring economic rate from Equinor Pipeline, which Equinor doesn't know in entirety, to Equinor Energy, which Equinor owns 100% of.
You could turn to slide 18, please. What are your four main takeaways here?
The Hansen report is fatally flawed. The damages estimates are unfounded and unreliable, and indeed, based on yesterday's testimony, even what the quantum of the damages claimed by Versa Energy is not known or clear to me. Second, the arm's length price for saltwater transportation services also equals the approximate opportunity cost incurred by Equinor Pipeline to provide those same services to Equinor Energy. Third, it is my opinion that Equinor Pipeline provided saltwater pipeline transportation services to Equinor Energy at reasonable and appropriate rates. Equinor priced those services based on appropriate market alternatives, specifically arm's length truck costs, further supported by the single instance of arm's length saltwater transportation cost. And finally, the principle of using arm's length pricing for the provision of goods and services between subsidiaries is long and well established. Subsidiaries regularly transact business both with third parties and amongst themselves, and they do so at on the same pricing basis.
Pass the witness.
Good morning. I'd like to begin by following up with you on the fair tender process. Mr. Ernest, you would agree the purpose of Equinor's fair tender process is to try and approximate what the market price would be that could be charged for the services, correct?
Yes, I would agree with that.
In other words, the idea is to set the same price for the services that could be sold if these two affiliate companies were third parties.
To set the approximate price, yes.
Even though generally speaking with this transaction, it's handled as an internal transaction because they have the same parent corporation, correct?
Repeat your question, please.
This transaction in this case between these two affiliates is handled as an internal transaction. It's a virtual sale.
I wouldn't agree the characterization is a virtual sale. As we heard Ms. Beck testify to yesterday, there is a transfer in internal books and records, Equinor, of monies from Equinor Energy to Equinor Pipeline for the provision of transportation services. It's economically meaningful recognition of the goods and services provided between these two affiliates,
So
these
you-
subsidiaries.
You disagree it's a virtual sale?
No, I think Equinor Pipeline is providing real transportation services to Equinor Energy. I don't see anything virtual about that.
Do you recall having your deposition taken in this matter?
I do.
I'd like you to have handed you a transcript of that deposition. Can you turn to page 66? Line 16, question, is there a reason why sold you put in quotes? And your answer was just to convey the understanding that it's a virtual sale. It's not a physical sale of the good or service to a third party. That was your testimony in the deposition, correct?
You have read it correctly, counsel. I'm just looking at the context in which the question and answer was offered.
And to give that full context, my full question there, paragraph 4.3 of your report I asked you about, this again touches on the subsidiaries transacting business, not just with other companies, but between themselves. You say in your experience, services are provided by one subsidiary to another, are sold at the same price as they are to other companies. Is there a reason why sold you put in quotes? Answer, just to convey the understanding that it's a virtual sale, it's not a physical sale of the good or service to a third party. That was the full question and answer on that section, correct?
That is correct, counsel. And again, I'd point out that I thought you were asking about the sale of the good or services between subsidiaries. Here, we're talking about the good or services to a third party. It is indeed not a physical sale of a good or service to a third party, but between subsidiaries.
And my question specifically is on we're talking about the transaction between Equinor Energy and Equinor Pipelines.
Yeah.
That would be a virtual sale, correct?
As I styled it here, but again, I mean, real physical services are being provided between the subsidiaries.
Services are provided, but it's an internal transaction where they're not collecting revenue with cash like in a third party, correct?
On the internal books and records of Equinor, Equinor Pipeline would be collecting cash from Equinor Energy. In the same manner, they would be collecting cash, or probably a wire transfer from a third party for this provision of the same type of good or service.
And I understand internally, so it's a bookkeeping matter essentially, correct? Handled by this overall company.
That is the way it's typically done, yes.
Okay. And generally speaking, the two companies, they're wholly owned subsidiaries of the same holding company, correct?
Yes,
And so they have common upper management, right?
at some point, yes.
And if Equinor Energy or Equinor Pipelines has a profit or loss, that ultimately flows up to the same parent company.
At some point, it would be consolidated into the overall books and records of Equinor.
So when we talk about the fair tender process, your report focuses on phrases like an arm's length price, but you would agree there's no negotiation back and forth between Equinor Energy and Equinor Pipelines, correct?
Not that I'm aware of, and again, as I described or testified to earlier, I think such a negotiation would be not useful for the purpose of establishing a reasonable and appropriate transfer price for the provision of transport services between subsidiaries.
And Equinor's fair tender process looks at what the cost would be incurred if the saltwater transportation services were provided by a third party to Equinor Energy rather than Equinor Pipelines. Is that fair?
Repeat your question, please.
The purpose of the fair tender process is to try and approximate the price that would be charged if the transportation services were provided by a third party to Equinor Energy.
Yes.
But in this case, it was not provided by a third party, it was provided by its affiliate, Equinor Pipelines, correct?
To be precise, Council, Equinor Energy received transportation services from Equinor Pipeline. It also received transportation services from trucking companies directly.
And Mr. Hansen testified that's not a focus of versus claim, so I'm specifically focusing on the pipeline gathering charges in this case. You would agree those services were not provided by a third party, correct?
I'm not aware of any instance where Equinor Energy received third-party transportation services for saltwater transportation.
And the fair tender process is also based on the hypothetical price that could be charged if the transportation was done by truck. Is that fair?
Not fair.
The prices are based on trucking costs. Is that accurate?
The rate established for saltwater pipeline transportation services by Equinor Pipeline to Equinor Energy is based on an assessment of the competitive alternative, which is truck transportation costs.
But we know in this case, that hypothetical did not actually happen in that the services subject to versus claim were not provided by truck, correct?
Incorrect, Council. Again, Equinor Energy did use directly truck transportation services. This is one of the reasons why they are aware, or were aware in 2019, and indeed in 2015, there was a need to rerun the fair tender process because the market conditions had shifted such that there may have been, in the fair tender process established, there was indeed a need to reset the transportation rates charged by Equinor Pipeline to Equinor Energy.
And again, you don't disagree, versus claim doesn't center on the services that were trucked, correct?
I agree with that, Council. And again, I would point out that nonetheless, Equinor Energy contracted directly with trucking companies. They were familiar with the market conditions and costs for truck services.
Okay. Let's talk about that process a little more. Your opinion is based on what the free market would allow to be charged through competitive alternatives, correct?
In this instance, we need a mechanism or methodology to establish the transfer price between two subsidiaries. The long-established principle is you seek to use a market-based mechanism to establish those transfer prices. In a circumstance where we have here, the competitive alternative to pipeline transportation is truck transportation. I find it reasonable and appropriate to use truck transportation, further supported by a third-party pipeline contract, to establish the saltwater pipeline transportation services provided.
So, to summarize, it's based on free market principles. That's my question.
Counsel, you say it's. What is,
The fair tender process is based on free market principles.
I would say the whole oil industry is founded on free market principles.
And I'm not asking about the whole oil industry. I'm asking about
If
the
I
fair
could
tender
finish without
process.
interruption, and the principles used to establish prices and services for, between subsidiaries is also based on the same general concept. The appropriate way to price goods and services between subsidiaries is to rely on the market rather than the internal negotiations of Equinor executives.
Okay. Want to make sure I understood your earlier testimony about your report, and then you testified about, I think, Exhibit 19, the new page on the, or maybe it was Exhibit 18, on the 2015 rates. So my understanding in your report, you could not locate the file that had been used to prepare the 2015 fair tender rates, correct?
And as it happens, Muse Stansel had in its possession via the production process, this file. But you didn't recognize it as the document or the Excel file that actually produced the 2015 transportation rates because the numbers didn't quite tie for, and if we can get into details if we need to. And so, and we assume that this workbook must have been a draft version, and there's a later version that we couldn't find, was actually used to develop the actual, or to calculate the actual 2015 rates. And so what we, Muse, did is do a reconstruction of the 2015 process using truck bids received by Equinor in 2015, and we did our own averaging, and we got very similar results. It's now become clear to me, or subsequently it's become clear to me, this is in fact the source document of the 2015 pipeline transportation rates.
Okay, thank you. Want to follow up a little bit on the 2015 process. So Equinor gets in all of the trucking bids, and then it averages out those bids to set the transportation rate, correct?
To be precise, what Equinor mathematically did is they averaged the rates for disposal services. They averaged the rates for the combination of transportation and disposable services. And they calculated the rate for just transportation services by subtracting the disposal rate from the total rate.
Okay, and so you would agree some of the bids that came in were much lower than the average that was charged overall, correct?
That would be the math. Some were lower, some were higher than the average.
Okay. So for example, your report references a table where QC Energy looks like the low bid at 126, which would be almost $1 cheaper than the rate that was actually charged of 217, correct?
Where are you looking, Counsel?
Table 2 of your expert report. This is at page 15 on Exhibit 17. Spencer.
And repeat your question, please.
So these were the rates for 2015, and QC Energy had a bid of $1.26 for Williams County, for example. You agree with that?
Yes.
And so that would have been almost $1 cheaper per barrel than the $2.17 rate that was charged, which is reflected in your Table 1 for Williams County. which is on page 14.
Yeah, that would be the math. I agree.
And would you agree with me that if this were actual free market principles, Equinor would try and operate with QC Energy because it has a lower price, correct?
I think we heard some testimony from Ms. Beck yesterday as to how it actually works in the field. There is a general desire to use the low or perhaps the lower cost providers where possible. I think it's also a fact that the lowest cost provider may not necessarily have the capacity to transport all the desired volume, and thus you're pushed into higher cost providers. There can be any number of reasons why. Or let me back up. I'd be deeply reluctant to use the QC Energy quote, and only the QC Energy quotation, for the basis of establishing the appropriate price for pipeline transportation services by Equinor Pipeline to Equinor Energy. Again, that's predicated upon QC Energy having sufficient trucks, drivers to handle all of the volume, which I think is highly unlikely. I'd also submit that the average calculation does not include the Frost Law surcharges. I'd also submit, as I discussed in my expert report, that it is my opinion, professional opinion, that companies would be prepared to pay a premium for pipeline transportation services versus truck transportation for a variety of reasons. Ms. Beck spoke to Medium yesterday.
Okay, and I'll follow up with you on that. I won't repeat the whole line of questioning with Ms. Beck, but just to close out this area, you would agree that Equinor, when it actually had to truck water, it developed preferred call lists to try and target the cheaper trucking companies that it could, correct?
I'm going to object to the extent it mischaracterizes Ms. Beck's testimony.
I'll overrule the objection, but counsel, could you try to be more precise with how you characterize that testimony?
Equinor developed preferred call lists based on the price of trucking companies, correct?
I don't know that to be the case, counsel.
Okay. Let's go to,
And what I mean by that is, you said based on the price. It is my general understanding that Equinor also considered other factors when they developed their call lists, having to do with safety, their general experience with the operators, et cetera, et cetera.
sure, there's other factors that apply, but generally speaking, they want to choose the cheaper trucking company if they can, correct?
That would be a better question for Ms. Beck. I
So
really can't
you have
speak
no
to that.
opinion on that, if you would want to choose a cheaper company?
Well, as to your new question, counsel, I would say generally companies to seek to obtain the good or service at a lower cost rather than a higher cost, all else being equal.
Okay,
In the case of trucking companies, it's clearly not the case that all trucking companies are equal in terms of their safety record, their operating performance, so on and so forth, and their capacity and capabilities.
I want to follow up with you on the Frost Law surcharges that you mentioned. So that has to do with load restrictions on North Dakota roads that are in place in certain times, correct?
Yes.
And there's surcharges that gets assessed by the trucking companies in relation to that. Is that accurate?
That's my understanding.
And so if I understand your testimony correctly, you're raising the Frost Law surcharges to show that a single rate is charged all year with the fair tender process, which doesn't include those Frost Law surcharges.
I would say if we look back at slide 8 of my opening presentation, where we're seeing a comparison of the simple average of the trucking cost versus where Equinor ended up with the rate for the provision of pipeline transportation services, Or at slide 10, where you see the same analysis for 2019. When you compare the simple truck bids to where Equinor ended up, you ought to have due regard for the fact that the averages for the truck bids does not include any consideration for the frost law surcharges, and they are real.
Okay, but you would agree that load restrictions don't apply to pipelines, right?
Correct.
So for the water I'd issue in this case that's going through the pipeline, those frost law surcharges would not apply in any instance, correct?
Not correct. It is my opinion that the appropriate means to establish the saltwater transportation rate is by considering the competitive alternative. The competitive alternative is trucks. Trucks include or incur a frost law surcharge during certain times of the year in North Dakota.
And pipelines do not, so that could not possibly apply to a pipeline transportation, is my question.
I don't understand your question, Counsel.
The frost law surcharge cannot apply to pipeline transportation, correct?
Not correct, Counsel. Again, we're using as a competitive alternative to establish pipeline transportation rates, trucking costs. Frost law surcharges are part and parcel of trucking costs.
I understand that. My question is, if you transport a barrel of water through the pipeline, you would not be assessed a frost law surcharge for transporting a barrel of water through a pipeline. Can we agree on that?
I would agree that if you transport a barrel of salt water via pipeline, a trucking company could not impose a frost law surcharge.
And if the surcharges were imposed, if it were trucked, that would be an actual cost that would be imposed in that circumstance, correct?
But I don't think it's a hypothetical that surcharges were imposed. I think they were imposed for trucking costs. Again, it is my opinion that you can think of Equinor Pipeline incurring an opportunity cost, a very real opportunity cost, when it provides transportation services to Equinor Energy rather than a third party.
And we could talk about opportunity costs later, but just to close out the surcharges for frost law, that would be an actual cost that Equinor assesses out if it's imposed on its working interest partners, correct? In other words, if Equinor has to pay a bill for frost law surcharges, it passes those costs along to its working interest partners, correct?
It's my understanding that if Equinor Energy, when it uses trucking services, if it incurs a frost law surcharge, that would be passed on to its working interest owners. It's my understanding that when Equinor Pipeline uses trucks to transport salt water between various disposal sites for various operational issues at their disposal sites, those truck costs are not passed on to either Equinor Energy or its working interest owners.
I'd like to shift gears a little, talk about your critiques of Mr. Hansen's opinions.
Council, could we now be a good time
Absolutely.
to take a break? So let's make it for about a 5 or 10 minute break. It's 10:29 and we'll go off the record.
Thank you.
Am I sequestered?
All right, we'll go back on the record. It's 10:39, and Mr. Ernest, I'll just remind you, you continue to be under oath, and counsel, you can continue with your cross-examination.
Just one bookkeeping issue before we start. Exhibit 17, Mr. Ernest's report, is a redacted version. We'll supplement it with an unredacted version after the hearing. Mr. Cook was okay with that.
That's correct.
Okay.
Mr. Ernst, I'd like to go back to the Oasis contract you testified about. You testified there was a single contract dealing with pipeline transportation that was available for Equinor, which was the Oasis contract, correct?
Yes.
And fair to say you wanted to analyze pipeline contracts if you could, but only this one was available, correct?
Yes, I would agree with that.
And the reason you wanted to do that is because you wanted to match the actual method of transportation by pipeline, right?
Well, I would say if if you had a multitude of third-party pipeline providing the same service in the same area available to you, you would probably just use those. You may also have due regard for trucking costs, but it kind of depends on the facts and circumstances at the time. The fact of the matter here, in this matter, trucking was really the only plausible competitive alternative.
Okay. The Oasis contract was between Equinor Pipelines and Oasis, right?
Yes,
And those two entities negotiated a rate in that contract, correct?
yes,
They negotiated that rate based on what the market would allow. Is that fair?
they negotiated a rate. For transportation services with additional provisions for a minimum volume commitment, which I've discussed has economic implications for both the party providing that commitment and receiving that commitment. It's also my belief that the rate that Oasis Pipeline could negotiate for the provision of pipeline services was certainly influenced by Equinor Energy's competitive alternative, which would be trucks.
Okay. And so would you agree the rate that was negotiated was not based on what it cost Oasis to transport water in its pipeline?
I can't speak for Oasis. I don't know.
Well, you testified it was a negotiated rate based on what the market would allow. So would you agree that it's not based on what it costs Oasis to transport via its pipeline?
Well, to be clear, the negotiated rate is what the market would allow. And whether or not Equinor Pipeline's operating cost was above or below $1.70 doesn't really matter. If hypothetically their operating cost is $2 a barrel, including fixed and variable operating costs and some perhaps return of capital component, and the competitive alternative to Equinor Energy basically caps the value of that service to $1.70, it is what it is.
Okay. Presumably Oasis wants to make a profit for itself when it's contracting with a third party like Equinor. Is that fair?
Well, once the pipeline's built, the rate you can extract from the market is based on the competitive alternatives available to the parties that seek to use or desire to use transportation services. Crude oil producers, refiners, they really don't care what the capital cost is for pipelines that transport crude oil from fields to the refineries. The only thing they care about is what's the toll. And the actual cost of the pipeline is not their problem.
Well, you would agree the cost is a consideration because they don't want to provide a service if they're not making money on it, correct?
Pipelines are highly capital intensive. A big chunk of the economic operating cost associated with pipeline operations is recovery of and return on capital employed. Their variable operating costs for pipelines tend to be quite low. So a pipeline company, in my observation, would certainly rarely, perhaps, provide transportation services for any lengthy period of time, something less than their variable operating costs. That doesn't mean pipeline companies don't provide transportation services at rates that don't give them their desired return on capital. The market doesn't guarantee anyone any specific return of or on capital.
Okay. And I think you answered my question there. Generally speaking, you would agree that Oasis in that transaction is not a working interest partner with Equinor. It's a third party, correct?
Object to the characterization as a partner.
Repeat your question, please.
The Oasis Equinor contract we're talking about, they were third parties to one another, that it was not an operator working interest party relationship.
Not as I understand it, no.
Okay. And so
No, being they're not a working interest relationship.
so the statute we're here about today would not apply to that contract, correct?
I understand it to be a legal question, counsel. I don't know.
Okay.
I'm not a lawyer.
I'd like to follow up with you on your critiques of Mr. Hansen's opinion. You testified a 10% discount rate, as was used by Mr. Hansen, would not be used to calculate the future overcharge claim, correct? Your opinion is that's not an appropriate rate.
It is my opinion that a 10% pre-tax discount rate is not the rate used by industry to buy and sell assets.
Okay. You did not perform any sort of analysis, though, on what the appropriate rate should be used, correct?
Counsel, I would point you to paragraph 516 at page 23 of my expert report, continuing on to the next page, where I did review the document or reference cited by Mr. Hansen as the basis for his 10% pre-tax discount rate. I would point out that Mr. Hansen's reference characterizes that 10% discount rate as, quote, not intending to reflect a fair market value, but it's more used to provide a consistent basis for comparing discounted future net revenues of different companies. And on page 24 at the top of the page, Mr. Hansen's cited reference further tells us that 10% rate he used is used for consistency with governmental regulations and standard comparative analysis, not because the rate is thought to include any risking and not because the resultant discounted future net revenue is thought to represent a fair market value. I agree with this document that a 10% pre-tax discount rate is not reflective of the discount rates that industry use to transact acquisitions and divestitures.
And my question is, you don't have any other rate that you've proposed, correct?
No, nor did I need to for the purpose of my expert report.
Okay. Mr. Hansen testified that Equinor has gathering systems connected to 95% of its producing wells. You don't have any basis to disagree with that figure, correct?
I do not.
He testified 83% of Versa's share of produced water goes through the David Nelson system. You don't do any analysis to dispute that figure, correct?
No.
And I won't go through all of the numbers that he went through, but, for example, the 87.5% that Mr. Hansen testified a lot about of produced water volumes that went through the pipeline, you don't have any basis to disagree with that figure, correct?
I understand what Mr. Hansen did in that instance. I'd point out that, as I recall, Mr. Hansen was using approximately a 3-year period to determine his 87.5%, whereas he's using a 8.5-year period for his damages calculation. So Mr. Hansen is using a subset of the available data for his damages calculations.
Okay.
I didn't investigate the matter further.
And that was my question. All of the figures Mr. Hansen went through, you did not do any analysis of your own to come up with alternative figures, correct?
That is correct. I was not asked to, if you like, rework Mr. Hansen's damages claim.
Okay. You would agree Equinor incurs certain expenses to operate its gathering system.
Yes.
It has to pay for electricity, for example.
We're talking about Equinor Pipeline?
Equinor Pipelines has to pay for electricity as one example of an operating cost for its pipeline system.
Yes.
And it would have to pay maintenance to upkeep the system.
Yes.
But while Equinor incurs those expenses, you would agree the rates are not based on those expenses through the fair tender process, correct?
The rates are based on the competitive alternative, i.e. trucking.
In other words, Equinor is not charging Versa its share of the electricity cost to run the system.
Not to run the pipeline system, I can't speak to how the power consumption at the production well pads is handled, Council.
Okay. And it's fair to say that you have not looked at any of the operating costs, such as electricity and maintenance we just talked about, for purposes of your analysis.
For the purpose of my analysis, I didn't need to look at the actual operating costs. Again, I wasn't trying to recreate or cure, if you like, Mr. Hansen's damages estimate. I did not look at operating costs. It wasn't relevant for my assessment.
And you testified earlier that subsidiaries are set up for the purpose of managing their revenues and costs, correct?
That is one of the reasons companies set up subsidiaries, yes.
But Equinor hasn't provided you any of those revenues or costs to analyze, correct?
Not that I recall, Council.
And if I understand your testimony correctly, you believe it's permissible for Equinor to structure its charges so that it's making a profit on the gathering charges. Is that accurate?
I think it is appropriate for Equinor Pipeline to use arm's length pricing to establish the rate or price it uses to provide those same services to a subsidiary. Whether that rate, as we discussed in the instance of Oasis Pipeline, generates a profit or loss for Equinor Pipeline isn't really material. I mean, the appropriate methodology that ought to be used to establish the rate for the provision of goods and services between subsidiaries is an arm's length pricing basis.
And again, the free market, you typically would price out a good or service to obtain a profit, correct?
In the free market, or perhaps any market, you seek to price out your good or service to obtain a profit. You don't always succeed.
And so in this case, is it your opinion that Equinor Pipelines is allowed to charge costs that make a profit?
It is my opinion that it is appropriate for Equinor Pipeline to charge rates that are consistent with arm's length prices for similar services.
even if that includes making a profit.
Can you have a
I-
more precise?
My question is, are they allowed to make a profit or not in charging Versa?
Who is they?
Equinor. Can Equinor charge Versa to make a profit?
My understanding is that Versa Energy and all the working interest owners are allocated their proportionate share of the costs incurred by Equinor Energy to produce the oil and gas. A component of those costs incurred by Equinor Energy is the cost to transport salt water from the well pad to a disposal site and dispose of that salt water.
And I don't think you answered my question. Can Equinor charge Versa to make a profit through the costs that we're talking about in this case, in your opinion?
It is, as I understand how the allocation process works, Equinor Energy is not earning a profit from charges or expenses assigned to the working interest owners.
Okay, but you testified you didn't review their cost, their revenues or expenses to make that type of determination though, right?
Well, it's certainly speaking to the principle I understand that Equinor Energy is using. I wasn't asked to do an audit of Equinor Energy's charges assigned to the working interest owners like Ms. Beck was speaking to yesterday, where Oxy and a number of other companies have engaged in audits that checked all the invoices and make sure they're being properly accounted for and properly allocated.
Maybe take a step back, the more general question. It doesn't matter to your analysis that Versa is a working interest partner or party to Equinor, correct?
In a sense, it matters because Versa is here because they're a working interest owner. If the question concerns how do you go about establishing the appropriate rate between subsidiaries for the provision of services, then no, it doesn't.
And that's my question. So your opinion in this case for the cost dispute we're here on today is that Versa's status as a working interest party is irrelevant to your analysis.
Well, I guess I'd put it this way. In the hypothetical where Equinor Energy had no working interest owners, I mean, they own the wells outright, 100%, it would be my judgment that the fair tender process would be the appropriate methodology to use to establish the appropriate price that Equinor Pipeline ought to charge Equinor Energy for pipeline transportation services.
Have you reviewed North Dakota Century Code 380808?
If that is the one that has the language about reasonable actual cost, yes.
And
I
that's
don't
the
have the
statute I'm
document
referencing.
memorized.
Okay. You would agree that statute doesn't say anything about allowing a profit, correct?
Object to the extent it calls for a legal conclusion.
Sustained.
The statute says what it
You
says,
sustained it.
counsel.
He sustained the objection.
Oh, sorry, I missed that, my apologies.
Yeah, you testified that this, I think your testimony was about the implications of this case potentially to all subsidiary transactions. Do you recall that testimony?
I do.
You would agree this statute we're talking about today does not apply to all subsidiary transactions, correct?
Legal conclusion.
Sustained.
Well, you're providing an expert opinion in this case about the costs that may be charged. I'm simply asking you if that opinion on the costs that may be charged, how you account for the statute that we're here on today.
Same objection.
Overruled.
Maybe the better way to phrase that was a poorly phrased question, is that all subsidiaries are not in an operator working interest party relationship. Fair?
I don't understand your question, counsel. Could you rephrase it?
When you're talking about the broader implications with subsidiary transactions, all of those subsidiaries are not in an operator working interest party relationship, correct?
I believe that to be the case. For example, I don't know that Equinor Pipeline has any working interest relationships.
Okay, so, but you don't dispute that when the statute applies, the parties have to follow the statute, correct?
Legal conclusion.
I mean, I'll overrule the objection. Part of his expert report his expert report relates to the statute.
Repeat the question, please.
When the statute applies with operators and working interest parties, you don't dispute that they have to follow the statute on what may be charged for costs, correct?
Not a lawyer, but that would seem to be reasonable from a layman's perspective, yes.
Okay. Thank you. I have no further questions.
Any redirect?
Just very briefly, if you could, do you have your transcript in front of you? I just want to address the attempted impeachment. If you could turn to the bottom of page 66. Are you there?
I have it.
And Mr. Cook asked you a question about the virtual sale. Remember that?
I do.
I'm going to read the question he asked right after that, and then I'll ask you to read your answer. He followed up by asking, what do you mean by that? What did you say?
Well, because the subsidiaries are all owned by the same parent. You're not collecting revenue with cash in a third party. It's an internal transaction.
No further questions.
All right. The staff have any questions of Mr. Ernest?
Mr. Ernest, on page 10. I believe this question was asked yesterday, but just for clarifying for the ones that weren't in here, when you show the third-party pipeline, that is a pipeline that is just a trunk line. It's not actually a gathering line that goes to the well pads. Is that correct?
It's my understanding that Equinor has some like feeder lines that flow into their origin point for this pipeline. This is perhaps more of a transmission line to a disposal, perhaps more than one disposal site.
Okay. And do you know if there's ever been any consideration on the joint interest billing to show one line for trucking and another line for pipeline costs for transportation of the water?
I don't know.
And I believe you answered this already, but did you run any numbers as far as the pipeline costs for operating or disposal or any of that for Equinor?
No, I didn't. Again, it wasn't relevant for my analysis.
Okay. Would you be willing to supply a supplement that kind of similar to this that shows what the operating costs of the pipeline are for Equinor?
Well, I'm happy to be helpful. I don't have, or more generally, Muse Stansel doesn't have in its possession, to my knowledge, that information. And I'm somewhat constrained by instructions too. Identifying or calculating pipeline operating costs is not something I was asked to do.
Is there the ability to get that information to be supplemented?
I think we'd have to talk with our clients about what information they still have, considering they don't own the assets anymore.
Well, you can consider that question as a request for that information,
We'll determine if it's available and proceed accordingly.
and we'll keep the record open after this questioning is done. Some housekeeping, we'll keeping the record open, and we'll set a time for that.
And just to clarify, if you're able to supply the supplement for that, the pipeline operating costs from the wellhead to the disposal, and that doesn't include the trucking, just the costs for the well that are connected to a pipeline from the wellhead to the disposal.
Again, I'm happy to be helpful. To be clear, I don't have access to that information, so ultimately it'd have to be Equinor providing that information.
Yeah, I got quite a few questions. I'm going to be jumping around, so please bear with me. In your understanding, when the fair tender process is used, the corporation in which is requesting the bids, they provide some outline or detail as to what they want in that bids, i.e. how many trucks you have, what's your capacity, so forth, so that the bidding companies actually know what they're bidding on, I guess. Is that accurate?
I don't recall. I have seen if you like, the template. I mean, I have reviewed the template that Equinor sent out to the trucking companies that they were supposed to use to base their bids, so everything is in a consistent format that they got back. Exactly what they asked for, other than obviously price, I don't recall at this time.
Can a corporation requesting those bids change what they're wanting in those bids?
Well, you can always, if I understand your question, you can always go back to the service provider and say, I want something different, please respond. Trucking costs, well, they're a strong function, or they're a function of diesel costs, and diesel costs move up and down. And so there's some back and forth over time between the trucking company and whoever's using those services or regarding the actual cost. There may be, for example, fuel surcharges built into the contract where the diesel price moves maybe outside of some kind of band. The cost moves proportionately.
So with that, and I asked this question yesterday to one of the witnesses, in some of the calculations, JMAC, for instance, was thrown out, and it was stated due to their costs being excessively high and not knowing why. Are you able to see why their costs are higher, and why wouldn't that be asked?
I heard two questions with respect. I don't know why their costs would be higher. As to why wouldn't Equinor ask JMAC, well, why are your costs higher than everybody else? That, one, in a sense, reveals confidential information that Equinor received from other truck companies about what costs they got from other truck companies, and Equinor, I think, would be generally reluctant to do that. And two, it's sort of not really Equinor's business. It's JMAC's business. If JMAC is uncompetitive, they'll figure that out pretty quickly because nobody uses their services. Exactly what's going on with JMAC, I really can't speak to.
So in the process, the fair tender process, you would take all your bids you received in to create your average, from my understanding. From your review, do you have an idea as to why JMAC was thrown out? Because it was still a correct bid, from your understanding. Is that right?
That is my understanding. It's, to be precise, sir, it's my understanding that for the 2015 fair tender process, the JMAC bid was included for the county's for which they bid. They didn't bid on all 6 areas. Again, as I recall, we can confirm that with a spreadsheet if we really need to. In 2019, they had, Equinor received, as I recall, fewer quotations back. In 15, they had 8 or 9 or something, and I think they had 5 or 6 in 2019. And in 2019, because you had a smaller set, the JMAC bid was more conspicuous, had a bigger impact on the average that you would calculate. And it appears that, I mean, I wasn't there at the time, but it appears like Equinor decided that this JMAC bid is simply not representative of market conditions, so they excluded it from the average.
So in using this process, and I'll do my best here to ask this question, but in using this process, hypothetically, if you only had, say, 2 companies that provided a bid back to you, and they were extremely high, is that really truly an accurate market assessment if there are other service providers that just simply didn't provide you a bid?
In your hypothetical, and I understand it to be, with respect to hypothetical, I would agree with that. I do believe, as Ms. Beck explained yesterday, that Equinor worked the bidders pretty hard. I mean, they knew who the trucking companies were out there because they used trucking companies to transport flowback water, for example, as a matter of routine from their production wells. And you know, Equinor is a very credible counterparty, pays their bills, and that's a desirable customer for a trucking company. It would be my judgment that most trucking companies, if they're in the business, would be happy to transact with Equinor. So I think it's a fairly unlikely scenario that there's a big pool of trucking companies out there providing trucking services, and only 2 could be troubled to provide Equinor with a bid, and those 2 happen to be the high cost or high priced vendors.
So from your experience, is there a circumstance in which Equinor Energy, would have performed or checked, done an audit, however you want to word it, I guess, with Equinor Pipeline to see what their actual variable operation cost was, and then set their charges based on that? So in other words, I guess a different way of asking that would be, instead of using the fair tender process, is that an option that Equinor could have used?
I see a number of issues with your hypothetical approach. I mean, it'd be fairly straightforward to estimate the all-in variable operating cost for a pipeline. But as we've been discussing at some point during the day, a big point of the operating cost for a pipeline, which is a capital-intensive business, is the recovery of and return on capital employed. And so now the very real issue for the commission, if they want to use some kind of return of and on capital approach, is, 1, you have to understand what the capital is, and 2, you have to decide what's the appropriate recovery period for the capital itself. Is it 3 years? Is it 10 years? And for the return on capital basis, you have a host of issues. Are you seeking to establish a return on capital that's consistent for all providers of pipeline transportation services? Or is it company specific? If it's company specific, you can do a cost of capital calculation pretty straightforward for a big, highly liquid company like Equinor. Because they're well established in the public markets. You can calculate the beta, et cetera. But not all midstream providers are Equinor. Some are private companies. How do you determine the cost of capital for a private company? I mean, the PhD economist will give you a number, and it's based on a bunch of theory, but it's exceedingly complicated. And if you don't want to adopt or elect not to adopt the concept of a cost of capital calculation or return of capital concept for individual midstream companies, but something more general for all midstream companies, then you have to decide, well, what kind of hypothetical capital structure are we talking about? What's the debt equity split? What's the appropriate long-term cost of debt for this hypothetical construct? How do you calculate the cost of equity for this hypothetical construct? What's the peer group you use to calculate the beta, and so on and so forth? It's a mess. I've seen it done in other proceedings, and you have dueling PhD economists arguing about this. Did that answer your question?
Wait, I think you're yes and no, and I guess what I mean by that is what I'm wondering is from Equinor's energy standpoint, being a separate entity, and we're saying that they could have, or that they did look at trucking as an option to handle the salt water. At any point, could have they looked at the actual cost that the pipeline, Equinor pipeline, actually had when they reevaluated in 2019 to verify that the trucking costs were either higher or lower as to what was actually charged of from the pipeline company prior, to compare that instead of going out and getting, multiple other options through the trucking? Because I'm wondering if the Equinor Energy had a certain contract obligation to use that pipeline anyhow, which would throw out the option to use the trucking up to a certain percentage or a certain volume.
Thanks for the clarification. I'd make this observation. If you want to try to establish your intra-subsidiary rate by something other than using the competitive alternative or trucking cost, then you're very much into an internal negotiation between the execs of the two subs. Equinor Energy would desire to use a long capital recovery period and a low rate of return on the capital employed. Equinor Pipeline would seek to do exactly the opposite, a short recovery period and a high return on capital. It's an internal negotiation. And where you end up in that process is a function of the internal power dynamics of Equinor. Which VP does a better job of negotiating or is closer to the CEO or whatever. And so you end up with a new number, but what does it mean really? I mean, if the Equinor pipeline is successful, you may end up with higher rates than what you've got than what you would have with the trucking alternative. I mean, there's no guarantee it's going to be lower. It's a negotiated rate, internally negotiated rate. It can be the same as, higher or lower. It all depends.
So by bringing in the fair tender process, in your view, you're limiting or reducing that ability to have that inner partnership negotiation that is not a real factor based on license.
Precisely. And, so when somebody challenges you on your rates, how did that get determined? It wasn't the consequence of a deal that got negotiated internally over the dinner table or at a restaurant somewhere. We looked at the competitive alternative, got valid third-party bids for transportation services, and averaged them. Or maybe we adjusted the average as we saw they did in 2019. Boom, we're done.
Do you have an opinion on what a fair return on capital should be?
It's very much a function of the risk attributes for the business in which that capital is employed. If, for example, you're a pipeline company and you invest capital in a pipeline project, and the throughput on that pipeline is backstopped by credible counterparties, credit-worthy counterparties, that guarantee throughput, unless your revenue stream, you would be prepared to invest that capital at a lower return than if you're drilling wildcat wells. So it all depends.
Equinor Pipeline does not collect third-party saltwater directly at well sites. Is that your understanding as well?
At disposal well sites?
Correct.
That is my understanding, yes.
So just, again, this is to make sure I understand, the discussion about opportunity costs coming into play in this decision, if the opportunity is not there for Equinor Pipeline, or at least my understanding from the testimony is that that's not an opportunity, why should that still be considered a factor then?
Well, it's, I understand your question, and it's a fair question. In a sense, it provides a theoretical basis for the cost approach, if you like. And again, I would submit that, as I described in the opening presentation, that the opportunity cost is not a new, novel concept. It is a very real economic principle. When you have multiple options that are mutually exclusive, if you select option A versus opportunity B, the benefit you would obtain by you selecting opportunity B is your opportunity cost associated with selecting opportunity A. The way Equinor Pipeline ran its business was such that they didn't seek third-party business. That's not to say that they couldn't have sought third-party business. I mean, there's no physical reason why third-party saltwater couldn't flow down an Equinor pipeline, saltwater pipeline.
Okay, thank you.
Sure.
Mr. Ernest, you talked about minimum commitments and contracts. Does that minimum commitment for the operator of the wells, does that make the contract more expensive or less expensive?
Well, to be precise, I discussed that sorry, Commissioner, I just want to get to the right page so we're clear as what we're talking about. Slide 9 of my opening presentation, the second bullet. The way I think about it is this. If, in this instance, and I think this example is generally applicable in general to the principle of minimum volume commitments, is that if I, Equinor Pipeline, is prepared to assure, in this instance, Oasis, of a guaranteed revenue stream backstopped by my balance sheet for whatever the term of the contract is, that has real economic value to Oasis. I know what my current and future revenue will be. If Equinor Pipeline doesn't ship the barrels, Oasis still gets paid. It's a take-or-pay contract. Guaranteed revenue is useful to a business. And so by giving that revenue guarantee by Equinor Pipeline to Oasis, if I were Equinor Pipeline, I would be looking to Oasis for a lower rate. That's the quid pro quo, right? I give you something, you give me something back. If you're not prepared to move your rate in exchange for a minimum volume commitment, you don't get a minimum volume commitment.
So in your opinion in general, why do oil companies use pipelines to transport salt water versus trucking?
For a variety of reasons. One excellent reason is trucks run over people and pipelines don't. If you desire to transport your oil and salt water, or if you have to transport your oil and salt water using some means of transportation, all else equal, you would pick pipelines over trucks all the time. They are safer, their environmental impact is less, and they don't have all the noise and road congestion issues that trucks have. There's also operational benefits for using pipelines rather than trucks. Trucks may be more impacted by, or not more, maybe, they are more impacted by weather, bad weather in particular, than pipeline operations are. And indeed, it's my opinion that companies would be prepared to pay some premium, not a massive premium, but some premium for pipeline transportation services relative to truck transportation services.
If it costs as much or more to use a pipeline versus trucking, what's the incentive by operators or non-ops to install pipelines?
Well, the cost for the upstream sub is the same, or approximately the same. And now it's a different set of business, it's a different business decision for the midstream subsidiary or third-party midstream provider regarding whether or not to build a pipeline. That decision would involve around, well, what's the capital cost required, upfront capital cost required to build a pipeline to be able to provide the transportation service, and what's the expected utilization of that pipeline both today and into the future. Because again, pipelines are capital intensive. Companies don't build pipelines expecting to use them for a year or so. You know, the general expectation is these pipelines will be used and useful for a number of years, so as to both recover the capital and generate a return on that capital. So that's the business decision the midstream companies make, and and what they do all depends on the facts and circumstances that at the time. If there's a single well producing water, that probably doesn't justify the installation of a pipeline, because you wouldn't earn a reasonable return of and on capital.
So as a non-operator, if it costs me 10 cents a barrel, let's say, we'll just use hypothetical numbers, 10 cents a barrel to truck salt water and 15 cents a barrel to run it down a pipeline, would a non-operator say, well, let's forgo the pipeline and we'll just truck it, it's cheaper?
They may, and if they may find during bad weather that production gets curtailed because they can't get the salt water off the pad, which is a problem. So that's part of the dynamic going on, or the consideration that goes on between, do we want to use truck, or do we want to use pipeline? And trucks are frankly messy. I mean, you got trucks coming in, on and off your pad, tearing up your pad. You got more invoices to deal with, more invoices to vet. Did they actually pick up that volume of water, in the middle of the night last week or not, on and on and on.
So in this fair tender process, it was discussed about the competitive alternative. Why wouldn't Equinor or any operator at the time expand its view or its research and look at other pipeline systems to estimate the cost?
It's my general understanding, and I'm from Texas, I'm not an expert in field infrastructure out in the Bakken, but it's my general understanding that the pipeline alternative as a practical matter doesn't exist, at least for this set of wells that we're talking about here. I mean, and so Equinor, nor could anybody else, go to some larger set of pipeline companies transporting salt water in the same general region and use that for the fair tender process. One thing I would point out is if hypothetically there's another pipeline company transporting salt water in the area that's not connected to your wells, and they know that, and you send them a request for bid, they're going to look at that and go, I'm not connected to your wells. I'm not going to tell you what my prices are. That's highly confidential, competitive information. They're just not going to do it. So even if there's other pipeline companies out there, your ability to access what their actual rates are is really quite limited unless you're doing business with them already. And you're doing business with the trucking companies. That's why when they get a request for quotation, they send something back.
There was some discussion earlier about high bids and low bids, and you may not want to use the low bid for certain reasons. I mean, you specifically mentioned QC. Do you have any information as to whether any of those trucking companies couldn't deliver the same level of service?
Not specifically. It wasn't something I investigated. It is my general understanding that, well, the number of drivers individual companies have, fluctuates because drivers come and go, trucks break down, et cetera, trucks get bought. And so, the service that an individual company can provide today may not be the same service level it can provide tomorrow for a host of reasons. And it's generally desirable to have access to not just a single trucking company to take care of your needs, whatever they may be, but multiple trucking companies.
But my question is, do you have any information that would say the low bidder isn't the best bid?
No, I don't, sir, other than the costs provided or memorialized in the fair tender process. That's the extent of my knowledge about the trucking companies specifically.
Okay, thank you.
Doesn't look like we have any additional questions. Thank you, Mr. Ernest, for your testimony here today. Do you have any additional witnesses to call?
No, we rest.
And same for, I have no rebuttal witnesses either.
All right. So do the parties plan on any post-hearing briefs?
I think we discussed 3 weeks.
Yeah, I think the plan was joint post-trial submission briefs and then maybe an opportunity for a response brief after that, but we'll defer. I think that was what we had proposed.
And by joint, you mean simultaneous?
Simultaneous, correct.
Okay. Let's see. Pull up a calendar. What's that? Sure.
2 weeks for a reply? Does that work for you?
So should we set a deadline of September 8th for
Works for me.
simultaneous briefs, and then
Does it work for you, Spencer? It's probably more important it works for you.
September 22nd for, I guess, rebuttal briefs. Then we'll keep the hearing record open until, I guess, the 25th for the unredacted E17. And then any additional information Versa wishes to supply in response to the questions from staff. So that would allow the parties adequate time to address it in their briefs. So anything else for the record?
The record remains open until what date, I'm sorry?
August 25th. Right. And yeah, so that includes the request from commission for pipeline operating
No,
costs.
understand.
Yep, okay. All right, and if there's nothing else, we will close the record at 11:35.
Thank you.
Thank you.